All right, let's discuss further. We're joined on the line now by Ulrich Roux, the director of BDK Attorneys. He's commentating, not linked to the defense. Mr. Roux, thank you for being with us. So this means 15 years, the minimum term for murder minus what he's served. What is he likely to serve, however?
Hi, yes, good evening. Thank you for having me. In terms of our law, he has to serve one half of his sentence before he can become eligible for parole. So he would have to then launch an application for parole, and then if he does qualify, then he will be released. So if one had to calculate that timeline, it does seem as if he would become eligible for parole in August 2024.
More years behind bars. This doesn't look good at all for the judge. Masipa now accepted that her sentence was shockingly lenient.
Yes, certainly there was a lot of criticism aimed towards Judge Masipa when she handed down the sentence of 6 years imprisonment. But that is if I can call it, the beauty of our law, that there is always an avenue that you can go down if you are not satisfied with a specific sentence or with a specific finding that a court made, and that is exactly what the state did here. I think what is alarming is the magnitude of the difference between the sentence handed down by Judge Masipa and that of the Supreme Court of Appeal. And here we must remember that the charge of murder carries a minimum sentence of 15 years. Unless the convicted murderer can prove substantial and compelling circumstances which forces the court to deviate from that 15 years. Judge Masipa had found that Oscar Pistorius' personal circumstances forced it to deviate extensively from that 15 years, whereas the court today, the Supreme Court of Appeal, found that the personal circumstances and the interests of society and that of Reeva Steenkamp far outweigh that of Oscar Pistorius, and that the court must send out a clear message to society, which I think they did. It was a good ruling, and it was a good sentence handed down, and I think a sentence which will deter would-be offenders from acting in a similar manner.
Judge Masipa was saying, yes, that his life was in ruin, so to some extent he had already been punished. That does sort of accept his celebrity status. So is the court really knocking that down, saying that that's really no argument that, sorry, you've fallen off a very high pedestal?
Yes, but remember that when reaching a just sentence, the court must take into consideration the personal circumstances, secondly, to the severity of the offence, and thirdly, the interests of society. And the court must blend all of that together with a measure of mercy in reaching a competent sentence. So she was not wrong in considering his personal circumstances and the fact that he had now, so to speak, gone from complete hero to an absolute zero. But the appeal court today said, whilst they did consider that the interests of the community, and especially Reeva Steenkamp's family, and especially Reeva Steenkamp, an innocent person who lost her life, should outweigh the personal circumstance of the convicted person, and that's handing down that 15-year sentence. I don't think there is too much to read into the fact that he was a celebrity. I just think that the judge, Masipa, made a mistake in placing such heavy emphasis on his personal circumstances. And on that point, I think what everyone must remember is that when you conduct a trial, there's a lot of emotion in the courtroom. We remember with Oscar Pistorius' testimony, he vomited while he testified. He burst out, he broke down and burst out in tears on numerous occasions. And all of these situations and scenarios play themselves out in front of a judge. Whereas in an appeal court, it's purely legal arguments on paper that the judges consider. So it's easier for an appeal court to distance itself from those emotions. And I think that is ultimately what made the big difference at the end of the day. I think if one had to look back at Judge Masipa's ruling, she erroneously felt sorry for Oscar Pistorius. She had sympathy for him, and she should shouldn't have. It should have been a pure legal question answered on legal principles, and that is what the appeal court correctly did today.
That's such an interesting point you raise. Finally, Mr. Roux, this question of remorse, also interesting. How do you judge remorse? He did say sorry, but it seems in terms of the appeal court judges, they're saying that was sort of a sorry, not sorry statement.
Yes, remorse is the most difficult thing to prove in our law. It is a difficult concept to grasp, and all our case law has time and again confirmed that it's very difficult to prove it, because are you actually remorseful for what you did, or do you regret it because of the situation that you find yourself in? And the appeal court today said that Oscar Pistorius was not remorseful. If he really was, he would have testified when he was sentenced. He would have taken the court into his confidence, and he would have reached out to the Steenkamp family from the outset. So the court really rejecting his argument that he was remorseful and only saying that he was regretful, and rightfully so. His life is ruined. He went from an international superstar to a person out spending at least 7.5 years in jail. So one would expect that he would be regretful, but I agree with the court. He did not really show remorse. He testified about how his life had been impacted by this, how he would never be able to recover. But what about the Steenkamp family? And what about Reeva Steenkamp, an innocent person lost her life? He didn't show any remorse for that. So I think the appeal court correctly pointed that out today.
All right, thank you very much. Ulrich Roux, the director of BDK Attorney.